An amendment to change the Missouri Constitution to legalize retail marijuana for adults 21 and over will appear on the November 8, 2022 ballot as Amendment 3. This ballot initiative is considered a voter-initiated petition. The current Missouri medical marijuana licensees and their supporters have a trade organization called the MoCan Trade Organization. The campaign is called Legal Missouri 2022 and is managed by John Payne, who is also the campaign manager to legalize medical marijuana. The petition was originally submitted to the Secretary of State's office in August 21 by attorney Mark Ellinger on behalf of the MoCan Trade Organization. The official ballot language was certified by the Secretary of State in October of 21. MoCan Trade provided funding to pay a firm out of Washington, D.C. to collect signatures on Missouri residents. Initially, Missouri County said that there was an insufficient number of signatures. Legal Missouri 2022 requested an audit and worked with the individual counties to validate the signatures they collected. The Secretary of State issued a letter of sufficiency for 6 of the 8 districts in Missouri, which is the minimum requirement to get a measure on the ballot. Amendment 3 only needs a simple majority to pass and become part of the Missouri Constitution. What appears on the ballot will be 6 bullet points. Do you want to amend the Missouri Constitution to remove state prohibitions on purchasing, possessing, consuming, using, delivering, manufacturing, and selling marijuana for personal use for adults over the age of 21, require a registration card for personal cultivation with prescribed limits, allow persons with certain marijuana-related nonviolent offenses to petition for release from incarceration or parole and probation and have records expunged, establish a lottery selecting process to award licenses and certificates, issue equally distributed licenses to each congressional district, and impose a 6% tax on the retail price of marijuana to benefit various programs. State governmental entities estimate initial costs of $3.1 million, initial revenues of at least $7.9 million, annual costs of $5.5 million, and annual revenues of at least $40.8 million. Local governments are estimated to have annual costs of at least $35,000 and annual revenues of at least $13.8 million. These bullet points represent a 38-page constitutional amendment. Constitutional amendments are different from legislation. If Amendment 3 passes, it cannot be changed by regular legislative action. Your elected representatives and senators cannot do anything to change the amendment. The governor cannot change it through executive order. The only thing that can change a constitutional amendment is another ballot measure. This is true even if marijuana becomes federally legal. As a government official, our Secretary of State, Jay Ashcroft, is not allowed to take position on individual petitions or individual candidates. However, on August 9th, when Ashcroft issued his letter of sufficiency for the Legal Missouri 2022 ballot initiative, he made this statement in his press release. I encourage Missourians to study and educate themselves on any ballot initiative. Initiative 2022-059 that voters will see on the November ballot is particularly lengthy and should be given careful consideration. This demonstrates how critical it is for the public to be educated about everything that is in this initiative. This amendment will actually change Article 14 of the Missouri Constitution, which legalizes medical marijuana. It makes some key changes to that bill. If you read it in the full language, you should note that information in brackets is proposed for removal, and information that is underlined is proposed to be added to the article. So how will the marijuana industry be affected? The amendment includes everything that marijuana industry lobbyists have been trying to get through the state legislature for the last 4 years. It gives more protection to medical marijuana business owners by defining unduly burdensome compliance measures as anything that subjects licensees or potential licensees to such high investments of money, time, or resources that a reasonably prudent business person would not operate the marijuana facility. It also gives them protections against records requests, disclosing personal identifying information. It reduces fingerprinting requirements for owners. It establishes Missouri income tax deductions for licensees. In Missouri, income tax deductions are based on federally allowable deductions. This measure creates income tax deductions since cannabis business expenses don't qualify for federal deductions due to cannabis being federally illegal. It makes font requirements for marijuana-infused product labeling less defined. All the current medical marijuana retailers, cultivation facilities, manufacturers, transportation, and testing facilities are automatically approved to be comprehensive licensees. There are currently 385 medical marijuana facility license holders. It will also establish up to 144 new retail marijuana business licensees spread equally among the state's 8 congressional districts and rolled out over a number of years. So how does Amendment 3 affect the healthcare industry? It allows nurse practitioners to give medical cards in addition to doctors. Prescribers will be protected from sanctions by their certifying boards and won't be subject to criminal or civil liability under Missouri law. It doubles the max number of people for a caregiver from 3 medical card holders to 6 and allows caregiver cultivators to have more flowering plants for a total of 24 flowering plants. How does Amendment 3 affect the consumer? You can see from the wording on the ballot language that people can petition to be released from incarceration or parole, which this initiative would make possible. But the language also adds have records expunged to the end of the bullet point, which is a little confusing because the initiative would allow the automatic expungement without petition. Expungement would be paid for by tax revenue from the marijuana program and not by those with records being expunged. It has preemptive language that prohibits the state from prohibiting a product based on THC content. The state will be able to establish serving sizes. It increases the time a license is valid and decreases the cost of the license. This will impact the revenue that goes towards the Department of Medical Marijuana Regulation. It provides protections for consumers in custody hearings, parole hearings, medical care like organ transplant, and employee drug testing because THC may show up on a drug test long after impairment. It also establishes civil penalties for violations like public use and possession of more than 3 ounces. Amendment 3 allows any Missourian to grow their own marijuana with a license. They can have 6 flowering plants, 6 non-flowering plants, and 6 clones. So seedlings, immature plants, and mature plants. This would make Missouri one of the 3 states nationwide that allows this many plants for home cultivation. It allows for possession up to 3 ounces of marijuana. It allows for the gifting of up to 3 ounces of marijuana. Consumers will be protected from search and seizure based on smell alone. While it does not allow consumers to drive under the influence of marijuana, it also protects consumers from prosecution for driving solely on the presence of THC or THC metabolites or a combination thereof in the person's system. This preempts any legislative authority to make that more strict. How does Amendment 3 affect the government? License fees will decrease revenues from the Department of Medical Marijuana Regulation. The tax revenue from medical marijuana will also decrease as retail marijuana becomes available. This means that the department established to regulate Missouri's medical marijuana program will be defunded. The 6% state tax would be split 3 ways between veterans' health care, drug addiction treatment and prevention, and the public defender system. The prevention funding is specific to overdose prevention and may not include broad youth prevention, driving impairment prevention, or use prevention for pregnant mothers. The initiative does not establish a department within the Department of Health and Human Services to regulate retail marijuana. So while it does allow the department to create rules regarding data collection, reporting, training, point of sale signage, and other regulations, it leaves it up to the State Department to determine which departments will do that. It gives DHHS authority to establish mandatory training for all sellers on or off premises that includes prevention and public health components. How does Amendment 3 affect law enforcement? Law enforcement will not be able to conduct search and seizures based on smell alone. So the initiative sets up parameters for how a search warrant for alleged marijuana offenses is executed. The data will be compiled and submitted to the Attorney General annually. How does Amendment 3 affect the community? The Missouri Auditor has estimated the bill will cost local governments at least $35,000 annually. You will see this in the ballot language. To allow for this, the initiative does allow for a 3% local tax on retail marijuana only that can be voted on by the voters. Remember that if a vote for a local tax is passed, there may be a delay in the tax quarter for when you can collect revenue. So if your local community has it on the November ballot, you may not collect revenue on retail sales until January. If your local community waits until April to have it on the ballot, you may not be able to collect revenue until July. Since this initiative would go into effect in early December, that could result in 7 months of lost local revenue. The initiative has narrowly worded language for local communities to opt out of retail sales after the first 2 years, with the first opportunity being in November 2024. This would need to pass with a 60% approval, but also allows communities to opt back in with a 50% majority vote. The amendment adds a definition for church that it has to be a permanent building, and adds a definition for daycares that it has to be registered with the state. It does keep public use and driving impairment illegal. How does Amendment 3 affect employers? There is specific wording in the initiative that says an employer is permitted to discipline an employee for working under the influence of marijuana. It does not prevent an employer from refusing to hire, discharging, disciplining, or otherwise taking an adverse employment action against a person with respect to hiring, tenure, terms, conditions, or privileges of employment because that person was working while under the influence of marijuana. However, it does not protect an employer from these actions just because an employee tests positive for THC. Remember that THC remains in the system long after use. How does Amendment 3 affect landlords? A lease agreement executed after this initiative goes into effect cannot restrict lawfully possessing or consuming marijuana by means other than smoking. So tenants will still be able to have edibles, vapes, tinctures, concentrates, and so on. How does Amendment 3 affect youth? We know that increased availability leads to increased use, and that can look different from community to community. It may mean that more youth are starting to use marijuana. It may mean that the same number of youth use marijuana, but the frequency in which they consume it goes up, or the potency of the marijuana goes up, all of which negatively impacts growing brains. The initiative does not offer the same level of provisions for youth prevention that it affords to industry and consumers. So while it does give the Department of Health and Human Services the ability to put in prevention measures that are not more stringent than those applied to the alcohol industry, the initiative itself does not establish a minimum age for employees or retail sales. It does not mandate responsible budtender training that would be equivalent to responsible server training for alcohol. It doesn't mandate that budtenders review laws and penalties that may be in place for selling to minors. It doesn't even establish penalties for selling to minors. It does not provide training of overservice or sales to impaired persons. It does not mandate education of budtenders for retail liability laws. Amendment 3 does not require compliance checks that would regularly monitor compliance with minor purchase laws. It does not establish a minimum age from entering a retail facility. And Amendment 3 does not require mandatory health-related warnings. It doesn't require point of sale signs that establish minimum age of purchase. Amendment 3 does not establish age restrictions for advertising audiences. While the Department of Health and Human Services will have authority to address these things, medical marijuana has been legal for 4 years, and they have not established rules regarding these basic youth prevention framework items yet. So it will take some advocacy work to make these a priority, as none of these things will be mandated by the initiative.